Good morning. This is Steve Wilkes at the Wagner Law Group here in our San Francisco office. On behalf of the firm, thank you for attending today's webinar. We're glad to have you. The webinar topic today is going to be about the independent fiduciary. It's a role that we see quite often in the prohibited transaction world and in the world of avoiding conflicts and trying to meet a standard of care and come up with a workable solution to problems. Our firm often serves as legal counsel to independent fiduciaries or parties in transactions, and in addition, we also have an independent fiduciary practice where we acknowledge our status as a 321 fiduciary and fill that role. So we have a pretty, I think, interesting perspective on the role of the independent fiduciary and how it works and what some of the special opportunities and needs and requirements are. So our goal today, I think, will be just to raise an awareness of some of the uses of the independent fiduciary. And what I want to do is I'll do a little history on how the concept has evolved through Erisa and the Department of Labor. And we'll talk about some of the specific uses that we see in class exemptions and individually granted prohibited transaction exemptions, and some places where the role of the independent fiduciary has been carved out in a statute. I'll also talk about some of the special situations where you're not necessarily addressing a prohibited transaction per se, but the use and opportunity for an independent fiduciary to step in and help make some tough decisions or clear conflicts, or simply be a resource for outsourced decision-making as an expert can really be helpful. And then we'll finish up a little bit. We'll talk about, the selection process and some of the qualifications for an independent fiduciary. So let's start with a little bit on the history. We saw, there was some, way back in the very beginning days of ERISA, there were some union settlements and court cases that began to build in the concept, which really arose under trust law. And then we saw it evolving in class exemptions and individual transactions. We've seen courts and the Department of Labor and planned fiduciaries and bankruptcy trustees actually appointing people. And again, the fiduciary just gives that, it's a condition that can be a workaround to satisfy an exemption. It can be an independent voice of support, if you will, for participants that handles conflicts, an additional layer of prudence. And as I'm sure many of you know that are listening today, just the whole world of prohibited transactions generally and the exemption process and the concept of independent fiduciary is sort of it's a body of practice and a specialty, if you will, of its own. So let's talk a little bit here. Obviously back, for those of you that have been around for a little while, if you remember back before 1974 when ERISA was enacted, there had been a host of some scandals and conflicts, I think, in some of the larger plans around the country, and some of them were union-dominated plans. But ERISA came about to address what was perceived as just a problem in terms of managing big pension money, and it brought a whole new heightened standard of care to the world, and just the notion of, appointing someone to act independently, we began to see as a fairly common solution. One of the very earlier cases involved one of the big union funds, and there was a big negotiated settlement between the DOL and the IRS in terms of how to, handle a case of substantial mismanagement. And it was a negotiated settlement. There had been a lot of loans and involving millions of dollars in commercial construction loans and what have you. So the situation that they worked out, the solution, involved appointing an independent fiduciary to kind of keep an eye on the assets, and an independent investment manager to come in and solve some problems, an independent counsel, independent accounting firm. So this got a lot of publicity at the time, and it became kind of a standard working solution. And they didn't, here what they really did, in effect, was appointed such new trustees to come in and replace the existing trustees, but I think it laid the predicate for the concept of having an independent party come in as a solution or as a monitoring mechanism or as an enforcement mechanism. And then also we see, coming from the, in the courts, there was a case, it's a pretty seminal case, it's known as Blankenship v. Boyle. A lot of people have talked about it. And this goes back to a situation where they found that there have been significant conflicts of interest and breaches involving a multi-employer plan. And they felt that the whole fund had been improperly operated. So, there was a union trustee, an employer trustee, and supposedly a neutral trustee. But they, just on an audit, they came across a lot of banking and cash relationships with an affiliated party that just didn't quite look right. So they felt that they really needed to, really get a grip on the entire process here. So again, this was a situation they didn't really appoint an independent fiduciary per se, but they came up with a kind of replacement slate of trustees, that were supposed to be independent and neutral. So these are some of the early predicates where we're seeing, the DOL and government agencies come in and just take a basic trust law concept and, come up with a standard, with a solution for conflict resolution and for solving these problems. I think just generally also in terms of, independent fiduciary. So we have these early, examples, and then, Erisa came on board, and, the whole notion of Erisa was that, we have transactions under 406A, we have fiduciary problems under 406B that might require relief or some special conditions, and clearly this is where the independent fiduciary concept really was baked. The original, I think the very first prohibited transaction exemption back in 75 had some other workarounds, but we began to see the independent fiduciary requirement starting in 76 or 77. And they were with some of the class exemptions, the standard ones that came out, for mutual funds and the insurance industry. And they talked about the concept of having, a second fiduciary or an independent fiduciary become involved to avoid conflicts and make decisions. And, there have been various definitions of independence over the years, and that's an interesting thing to track as well. Sometimes a fiduciary is deemed to be independent, as long as there's no relationship to or interest in the person that might affect the exercise of that fiduciary's best judgment as a fiduciary. And that's interesting here. It doesn't rely on a mechanical stock ownership test. It allows for situations where there might be enough of a relationship to have a problem, but technically you don't meet the definition of an affiliate or, controlled, entity or related person, which might be defined by some stock, overlapping stock ownership or something. And, sometimes they define in the negative. They tell you what's independent by giving examples of, what's not deemed to be independent. And there are a lot of great examples in the exemptions, including, 9662, which has some of the procedures for individual exemptions, and the DOL pamphlet on Erisa exemption procedures, which I'll point out later. So, again, the concept here was, like in 77-4 was that, the fiduciary would make a decision and they would have to be notified of any change, for ongoing transactions. So it was sort of an ongoing role created for these fiduciary parties. And the same thing in the after 77-4, there was 79-1 and some others came along where there were independent fiduciaries were required to make judgments and maybe annual written reauthorizations, things like this. So this is where the concept really began, and it continued on through the years. In-house asset managers and QPAMs and so on. So they really got built into the system, and that's sort of history of where they came from. Now there are a lot of different uses and examples that we can see in the class exemptions. I listed a few on here for you. And these are really good to take note of. They're good examples of the use of independent fiduciaries. They have good definitions on the qualifications perhaps for a fiduciary, and maybe how to define independence. Like the QPAM has some definitions of its own on independence that I'm sure that you're aware of. One of the more frequently used one of the more frequently used exemptions that we see where we have an independent fiduciary is the litigation settlement, and that's instructive. So I think it gives a lot of good examples on just how to use an independent fiduciary and so on. So let me talk about it a little bit because we get a lot of questions about it. So basically you have an independent fiduciary, for these exemptions. That means there's an underlying prohibited transaction, and clearly, the DOL held with regard to settlements that, when a plan, fiduciary releases a claim against someone that's a party in interest, that could be a prohibited transaction unless there's a workaround on it. So, participation is problematic, and it creates, DOL problems and excise tax exposure under the code. So back in 2003, the exemption for litigation settlements came along as 2003-39. It was amended in 2010. And you get an exemption for the release by the plan or fiduciary, of a legal or an equitable claim against a party in interest in exchange for consideration given by or on behalf of a party in interest in settlement. And one of the conditions is that the settlement is authorized by a fiduciary. And that person, this authorizing fiduciary, must have no relationship to or interest in any of the parties that are involved in the claims other than the plan itself that might exercise that person's judgment. Now, there were some questions about who's going to pay for this process, and if you go back and look at the preamble to the original exemption, you can see that the mere fact that someone is paying doesn't necessarily destroy independence, provided that the professional being paid by the party understands that it's the plan, not the party paying the bill, it's the client, and that it's just, it is no more than a small percentage of that person's gross income. So, there's some pretty good guidelines in there. And what they're really saying that an independent fiduciary is going to do here is, they have to determine whether the settlement satisfies the conditions of the exemption. They have to negotiate changes to protect the plan. And if there are any changes, the fiduciary would have to authorize that settlement. You have to make a decision whether the plan should opt out of the settlement, if it's in an opt-out class, identify any objections. And if there are class members that have to file claims, the independent fiduciary might have to actually prepare and file the claims or determine how the proceeds are going to be allocated. Then there's a whole process for filing, for making certain findings under the exemption. You have to see if there's a genuine controversy, and, you have to meet certain requirements concerning the settlement terms and the scope of release and the amount of cash or non-cash rewards, and you have to make sure that any extension of credit in connection with a settlement, is reasonable and considers the creditworthiness of the party in interest, and so on and so forth. So there's a lot of process in there, but I think it's a good learning tool for anyone that wants to understand some of the terms and conditions that can be built around an independent fiduciary. So I think also I would just say that there are other examples in terms of class exemptions that are really, really helpful. But when you look at 96-23, for example, in-house asset managers, you can see you see where it's not necessarily an independent fiduciary, but yet there's a variation. You get requirements for independent audit. So if you were to do a search for the word independent in any of the in all the exemptions that have been proposed or granted, or the published procedures, from the DOL, obviously that word comes up quite a bit, and it just plays through independent fiduciary, independent audit, independent consideration, so on and so forth. So it's really, really key. And it's also important to remember that the definition of independence can vary a little bit, so you have to be careful for, which one you're working on. Now, in terms of, obviously there are class exemptions out there. Class exemptions don't always work for every specific situation, and a lot of times, individual exemptions are granted, which end up requiring the use of an independent fiduciary. It's really become part of the, one of the standard ingredients, really. So, the DOL can grant an individual exemption, as a conditional or non-conditional exemption. And I've looked at a lot of exemptions, and there's an old, there's an old ABA report from years ago by our good friend Bill Wade of the K&L Gates Law Firm, which is still referred to by a lot of people. He did the in-depth study. We're currently working on another one, just trying to update some of that kind of work. But you can see patterns on where independent fiduciaries or some sort of independence requirement has worked, or where its failure to be present, has not helped, or even where it's present, sometimes it doesn't get you all the way. It doesn't get you all the way through. If you look at the DOL website, I put the site on there. They break down that the number of categories in which exemptions are granted, and almost pretty much all of them, if not all of them, at some point, will rely on an independent fiduciary for as part of the solution. It's really pretty amazing. I'm going to try to summarize a few, some of the ones that we've come across now that rely on an independent fiduciary, just to give you a little flavor. And again, I think it's important just to remember that, that the DOL has the ability to, to grant these exemptions, and they literally have issued thousands of them. You have to, it's really quite an undertaking to, study the whole thing. But let me see if I can walk you through some of the examples. This is in the general category of sales or leases or loans among a plan. I found many examples where there's a specific use of an independent fiduciary. Now, we have to remember, just generally speaking, just from a policy and procedure point of view, that when in the statute, when they give an exemption, I guess Congress has decided that it's okay to grant an exemption, and these generally fall into two kinds. There are certain things that really need to be allowed because they're just deemed to be of commercial importance, even though technically they fall outside of ERISA's requirements, or they just have the potential to benefit the community, and as long as they have substantial independent safeguards, those are the magic words from the House Conference Report, substantial independent safeguards for plan participants and beneficiaries, you're going to get there. So that kind of gave them some of the background guidance in terms of granting these exemptions. In terms of the categories, like I said, they also, sometimes, the department, the DOL might look on, the presence and active involvement of a qualified independent fiduciary. They're looking at the beginning of the transaction, but certainly prior to engagement. If you go back and look at the old letter from Jeff Clayton, the old predecessor to EBSA, to Lee Irish, those of you who've been around for a while remember that was back in 1984. There's some good guidelines in that letter in terms of when the independent fiduciary needs to be involved. But clearly, in terms of whether you're involved at the beginning of a transaction or come into it later on, there's a certain question about how much oversight is required, how much investigation is needed, on the DOL side. And what they've said is that the department requires that an independent fiduciary be appointed to represent and protect the interests of the plan and its participants. And the designated fiduciary must be a qualified person sufficiently unrelated to the parties. And this minimizes the potential for conflict of interest. And it enables the department to rely upon the independent fiduciary's expertise and judgment. In other words, the DOL doesn't necessarily want to go in and investigate everything prior to the transaction and everything following. They're really looking for the independent fiduciary to step up and into that role. That's the whole point. So therefore, you need to, the independent fiduciary needs to make a pretty comprehensive analysis and a lot of representations, and maybe even monitor the transaction. It just varies. They've also noted that when the independent fiduciary is an individual as compared to an institution, that it's preferable to have outside legal counsel, working with them. So, like in terms of, I've gone through on these categories, looking at, sales to plans, leases, loans. Clearly, one of the very common conditions for exemptions involving sales of property is an independent valuation, which can be undertaken, by an independent appraiser. But this really goes hand in hand with an independent fiduciary whose responsibility is often to properly engage and determine, an appropriate appraiser to come in and do the valuation. So, an independent fiduciary will review and approve a transaction on its own, or it might acquire an appraisal by a qualified independent party. And there's a history, you can go back and see some of the old exemptions. They didn't always, some of the early ones, the individual ones, didn't necessarily require approval by an independent fiduciary. Like there were some financial transactions where if there was a good guarantee behind it to maintain the financial integrity, maybe they would have allowed to go through. But there's also a lot of denials that you can see. You can see stuff that was filed but never, requested but never granted. I mean, clearly there's a very high percentage of transactions with a lack of some sort of independent appraisal or independent safeguards, are the reason for the transaction, being turned down. And again, the determining, whether the transaction was in the best interest of the plan, sometimes you can't tell. That's, that's hinged on a requirement that the plan fiduciary determine that, or the valuation speaks for itself. But this is something that they're looking at. When there's a limited number of participants, sometimes a transaction might go through a little bit more easily. I found one old transaction involving the sale of raw land, and clearly it's kind of a casebook example. It was back in 1988 or 89, but the sales price was great. I was kind of surprised to even submit the thing. The sales price was greater than the fair market value was established by the appraiser, and it just got turned down. So that was a pretty clear cut example. So, but when you look at these again, when you look at these as a whole, the reasons for denying exemptions, a lot of times they're too risky, or it wasn't necessarily in the best interest. But I think the most common denominator is an absence of independent safeguards, or the failure of an independent fiduciary to be present to assure that the valuation was right and it was the best interest, and solve conflict issues. See the same thing on leasing deals. When you go back and look at the old deals, clearly they're always looking at fair rental value to be determined by an independent fiduciary or by an independent appraiser that was hired by an independent fiduciary pursuant to some sort of process. Independent real estate consultants are helpful provided they're qualified. The leasing deals clearly are looking for good terms in terms of reasonable duration of the lease. They're looking for renewals with the advance approval of the independent fiduciary. They're looking for the initial rent on a net basis, valued properly by a qualified independent appraiser who's reporting to an independent fiduciary. Periodic ongoing appraisals from an independent fiduciary or an appraiser that get hired. So we see that concept is just totally baked into all of the sale and leasing transactions that we have. Same thing on loans. There's some interesting loan transactions between parties, independent fiduciary, either a loan by a plan or to a plan, involving, commercial notes, any extension of credit really. It's, the independent appraisal on the collateral, reasonable rate of interest on the loan terms, all hinging on independent fiduciary sign-off. And sometimes not only just to approve the transaction, but to monitor the terms of the loan repayment, during the course of the transaction. And there's just a host of interesting examples out there involving, inventory financings, mortgage loans, end loan financing, floor plan arrangements. The ones that worked all had independent fiduciaries on them. That's the C. That's the key. And the ones that were denied, even clearly, the department is calling out the lack of safeguards to protect the interests of plan participants, always citing number one. It's always the independent fiduciary is, the lack of an independent fiduciary, which has been the problem. And you get the same thing on, just a continuation, plan service arrangements, in-kind contributions of property. These are all examples, employer securities, public companies, looking at unitized funds or just valuations on private deals, ESOP deals. They all hinge, all the examples that we came across all hinged on having an independent fiduciary in place, to approve the transaction, to monitor the transaction, to ensure that there is a good appraisal. So, and you can see, there are examples, involving collective funds back before the statutory exemption. It's a pretty long list. So these are just some of the areas in which they've issued, in which we've seen class exemptions, and it's a pretty powerful list. There's also, individual exemptions, and then you also have, I think the exemptions obviously have gotten a lot more complicated over the years because our financial services and products have gotten a lot more complicated. But we have many examples involving major institutions, like BlackRock and J.P. Morgan, that sometimes don't quite fit into a statute, or other applicants that don't quite fit into a statutory exemption. So they do a variation, and they craft something around a class exemption, and the department has been able to work, with it. But it's always the independent fiduciary that has made the difference. And the independent fiduciary, especially after the Pension Protection Act, we see it in the statute as well, with participant advice, alternative trading systems, cross trades, bank deposits, collective vehicles, common trust funds. These are all examples where we see the independent fiduciary in the statute. Now, a lot of you already know this. You're aware of the exemptions and you follow them. But I think that what we've seen a big increase in, and our firm has been involved in a lot of, I'll just call them special situations. There's not necessarily a prohibited transaction, but the trustees the plan fiduciaries are calling in. They're really outsourcing some decision making, and they're calling an independent fiduciary to put a second set of eyes on something, or to provide some comfort. And we're seeing those in terms of social investments, which might not be traditional, and they're wondering whether it's appropriate to make that kind of investment. We do a lot of ESOP work as independent fiduciary with valuation, reasonable interest rate on the loan, just typical M&A deals, or just engaging in the transaction, just to buy or sell. On the public side, it usually involves a unified stock fund or something like that. On the private side, it's more around valuation. Every combination of real estate transaction you can imagine, tender offers. Sometimes there's a question on in-kind contributions, whether a funding obligation will be met. We've seen recently a lot of, larger plans, institutions and Taft-Hartley plans that are interested in, alternative investments, but the trustees are not necessarily comfortable with, making, the decision. They're not quite sure how to do the due diligence, and they're really outsourcing, and, the investment manager or the party bringing the deal, to the table might have a conflict. So, independent fiduciary has a chance to come in and make the decision in that regard. And as I said before, just all the scenarios involving, public company stock. So, the independent fiduciary, it's in these situations not necessarily meeting an exemption requirement, but it gives plan participants a chance for someone to stand up and sort of, be their independent voice, their expert voice. Maybe it allows a plan to take advantage of some investment opportunities that the prohibited transaction provisions, might preclude or scare you away from a little bit. It helps address conflict situations. And, there's an extensive, body of law around either going for an exemption request or just, even if it's not going to be submitted, just having a fiduciary on board to help with the decision-making process and just to outsource the fiduciary making. So again, managing stock, tender offers, contributions, security class action matters, union sales. We see a lot of activity with union sales to plans, mergers of funds or investment vehicles. And it's always important when you're bringing on an independent fiduciary in these situations and you're not dealing with specific terms and conditions of an exemption that can give you a roadmap. You have to know up front whether your independent fiduciary is going to only be providing advice or actually exercising discretion. And you need good agreements and good contracts, around that process. You need to know if your independent fiduciary is going to actually step up and be a 338 manager or some other role. You need to know what kind of experts or consultants the fiduciary might be relying on, whether there's any reporting involved, either to the Department of Labor or just as a documentation of the process. And indemnification is always a big discussion as well. What kind of insurance does your independent fiduciary have, and what kind of indemnification is allowed and expected among the parties? And, we've just found that independent fiduciaries are able to step in and provide a lot of help. They can basically make decisions for fiduciaries that otherwise, the insiders have conflicts, it's too risky for them, and maybe, or just to step in with the right expertise and to really be responsible to the plan participants. So again, you also need to know what kind of independent consultants, as I said before, might be added. So there's a lot of special situations where fiduciaries are stepping overseeing, which goes beyond the traditional, the more traditional roles of meeting an exemption requirement. That's the reason I mentioned here. We know what the class exemptions require. We know how they're used on individual exemptions, and we're seeing them a lot of independent fiduciary work as well, where it's just a second set of eyes. This is an outsourcing of fiduciary responsibility by the people that otherwise would make the decision. So and you always have to make sure you have the right process. When you're appointing a named fiduciary, you have to be working, of course, within the statute and maybe the terms of the plan documents. So in terms of, expertise and things like that, who is, the DOL has an excellent publication. It's on the website, which I have. I think I put it on there for you. It's called DOL Exemption Procedures Under Federal Pension Law. And there's some really, really good discussion in there, but not only about the exemption process, but about what is an independent fiduciary for purposes of the statute. And there are some here. The definition kind of relates on revenue. It presumes, it looks at taxable income and revenues, and there's a presumption that if you don't exceed a 2% limit, you're okay. If you're between 2 and 5%, it could be a problem. A little more of a argument, perhaps, and it kind of presumes over 5%. That's a problem. And so then that's a totally different test than what you see, for example, in the QPAM definition. So it's very careful to really understand the nature of the relationships, both from a technical, from a technical point of view in terms of defining an affiliate or related party, and just remembering that there were times when, you're almost over the line in terms of a technical problem, but you're not quite there. And you have to look at issues as to whether, how your judgment nonetheless might be affected under the facts and circumstances, and looking at the independence on a revenue basis. So those are the things we're looking for independence. Qualifications, it's pretty obvious. I mean, when you really think about it, it's not really different than defining an expert, for any vendor. And the process, it's, making sure that whoever you hire as your independent fiduciary has the right training, the experience, the bandwidth, the resources, the capability to act. And when you read a lot of the published exemptions, they don't really have an elaborate definition of qualifications anywhere or guidance, other than when you look at the exemptions themselves that have been granted, and you can see the parties from the transaction, it becomes self-evident. You can see how that fiduciary, kind of fits into a particular situation and why they were approved by the DOL. And the selection process is the same as, I think, really for any selection. Selecting a service provider to a plan in and of itself is a fiduciary activity. And that's something to also remember. Boards and fiduciaries that bring on an independent fiduciary, they will always have the residual responsibility to supervise and to perhaps monitor a little bit in terms of the process. So even though you're outsourcing the responsibility, the authority, the liability for a lot of the decision making, some of it is still going to be retained by the named fiduciary, or a couple of comparisons to look at, and just having a good process and documenting your process for selection. So I think that pretty much sums. Our goal today was to call out, the numerous roles that independent fiduciaries can play on class exemptions, the various situations where they're called for. Similarly, by statute, they're part of the process by which individual exemptions are granted. And finally, special situations where fiduciaries are just looking for, an additional set of eyes, someone else to help, share the decision making or to take over the decision making, where the expertise is required. So I think that's it. If anyone has any questions, please contact me, here at the firm. I'd be glad to follow up and give you some specific sites and some class exemptions or individual exemptions that have been granted depending on the facts and circumstances that you're looking for. If you have any questions about how an independent fiduciary might be used or where it might fit into a situation with, any ESOP situation, public stock, alternative investments, do, a lot of Taft-Hartley work, where, it might not necessarily be a prohibited transaction where you need an exemption to be granted, but nonetheless, given the interplay of, union trustees, employer trustees, neutral trustees, sometimes there's, Taft-Hartley plans like to see that decision-making outbound. So thank you very much for your time today. Please contact me at the firm if you have any questions, and enjoy the rest of your day. Thank you very much.